You ready?
Oh, it can pause. Go ahead.
All right. This is Lachelle Jet uh, on YouTube at the Dekalb County Jail being falsely accused. Anyway, I'm here to talk about uh, the false indictment that's happening in DeKalb County. I'm here to use court transcripts and also read letters and do as much as I can, and also use case law to expose what's happening in this DeKalb County jail. So y'all just bear with me. And here we go. All right. I have a letter to the Attorney General, Christopher M. Carr, and it's from DeMonte Dontrell Anderson. And this is what it reads. My name is DeMonte Dontrell Anderson, and I am a detainee at the DeKalb County Jail Facility and represents himself for criminal offenses in DeKalb County Superior Court jurisdiction. Reaching out to you to inquire about the letter I received from you all's office with Senior Assistant Attorney General Tina M. Piper as the sender that dated December 22, 2023. And the response to my letter received by your office dated December 7th, 2023. I discern the language in your response exhibit A declaring the Office of Attorney General provides legal advice and representation for the state of Georgia and all state agencies and departments, as well as certain cases involving judges, and district attorneys. The language outlined in my initial correspondence via form the DeKalb County Superior Court has made it obvious that they intend to keep imprisoning me until they can see what type of unlawful acts they can commit against pretrial detainee Deontay Davis, whom of which was the first pretrial detainee to tell the Honorable Hanging Judge Courtney Lynn Johnson about her severe violations of OBGA 45-10-1. She displayed at my jury trial February 2020, in which he was duly sworn in under oath in front of the other public officers at his February 14th, 2023 Beretta hearing without being held in contempt or penalized for perjury prior to her voluntarily recusing herself from his case. I reached out an innumerable amount of times, but this time is to question the negation between the two correspondence exhibits A and B, because I went to a motion hearing September 5th, 2023, before a proven incompetent judicial officer sitting by designation name David B. Irwin, in lieu of going before my assigned governor appointed judicial officer named Brian E. Lake for reasons unknown. At this hearing, David B. Irwin insulted Mr. Carr's knowledge of the law and his office by stating, well, if you are putting your hope in the Attorney General, who did not practice law when he was appointed Attorney General and had to repay his bar dues, then your hope may be misplaced. And so once I received and thoroughly read the legal correspondence after I sent my original correspondence prior, I did lose hope in his office because I've been endeavoring to report allegations of public corruption deriving from several public officers of the DeKalb County Superior Court and the rectification from superior government officials has been loathsomely disreputable. Okay. Now, from what we can see, there are three indictments. Now, this is just me talking right now. There are three indictments, two of which share the same court and one that does not. And it's Jenny Neal, his court case number is 21CR2242. Mark Fleck, his is 21CR2561. And Lorenzo King, his is 21CR2686. And there is proof of fake indictment because all three of these have the same forged grand jury four-person signature on the face of their indictment, and the name on the indictment is Renee Rose. There's no way that a grand jury four-person can be assigned to two different courts on three indictments with a carbon copy name. Okay. Also, next, we're going to talk about the, hold on. We're going to talk, I got some questions that I'm going to ask, that I'm going to answer while I ask. The first question is, tell us about the proof of the Dekalb County District Attorney's office using force, grand jury person's signature, or illegally filed indictment. And it says the validation are the several bills of indictment I have here that were not returned in open court as the law provides. And the law for that about the open court. While I'm talking, I'm going through the paperwork I got. So y'all gotta bear with me. All right, here we go. All right. So, open court. Now, according to handling indictment, it says the relevant law within Daniel, the Georgia Criminal Trial Section 1318. It says that the defendant is in jail. If a defendant is in jail, he is entitled to be released as soon as a no bail is returned. Likewise, if the accused is on bond, he and his surety are released, subject to his being rearrested if he is later indicted. Secondly, open court. In State versus Brown, the Georgia Supreme Court held that open court means that the indictment must be returned in a place where court is being held open to the public with the judge and clerk in attendance. The court also held that the failure to return the indictment causes per se injury to the defendant. Secondly, the second question is, it says, please tell the world what does it mean for something to be presented in open court? And again, that's according to relevant to the law within Daniel's Georgia Criminal Trial Section 1318. It says that open court, as the term is used in connection with an indictment, means the place where court is held, which is open to the public with the judge and clerk of the court present. The rationale underlying the requirement is the deterrence of indictments returned in secret and the appearance of a grand jury acting as a star versus, that's Curcio versus Sanders. It says that an accused after return of a no bail is released subject to being rearrested and new recognizance required upon the initiation of a new bill of indictment. It seems though that there would be no need for a bond to still indictment. So, and then also in Thomas versus State, it says that objection to indictment was not returned in open court is waived if not raised prior to trial. So the next question that we got is, give me a second. Question 3: do you know what happened in Mr. Anderson's case at his September 5th, 2023 motion hearing? Now, what happened at his case was it was proven that they had the judge had mocked him. The judge had mocked him and like made fun of him and wouldn't use anything that he was trying to say. But I got some case law for that, and the case law I have for that is right here. It is Georgia Code 15-6-6, oath of the judge. And it said, before entering on the duties of their office, superior court judges must take the oath required of all civil officers. And in addition, they must take the following oath. It says, I swear that I will administer justice without respect to person and do equal rights to the poor and the rich, and I will faithfully and impartially discharge perform all the duties incumbent on me as judge of the Superior Court of this state according to the best of my ability and understanding and agreeably to the laws and Constitution of this state and the Constitution of the United States, so help me God. Secondly, OCGA Code 16-10-1, and it says display the language outlined within Georgia Code annotated is any public officer who willfully and intentionally violates the terms of this oath as prescribed by law shall upon conviction thereof be punished by imprisonment for not less than 1 nor more than 5 years. Once I finish giving y'all the code, I'm going to get y'all the evidence. Give me 1 second. I'm turning pages and trying to talk at the same time. Secondly, Georgia Code 15-10-1 says there is established for and within the state and and in all governments therein a code of ethics for government service which shall read as follows. Any person in government service shall put loyalty to the highest moral principles and to the country above loyalty to persons, party, or government department. Uphold the Constitution, laws, and legal regulations of the United States and the state of Georgia and of all governments therein, and never be a party to their evasion. Give a full day's labor for a full day's pay, and give to the performance of his duties his earnest effort and best thought. Seek to find and employ more efficient and economical ways of getting tasks accomplished. Never discriminate unfairly by the dispensing of special favors or privileges to anyone, whether for remuneration or not, and never accept for himself or his family favors or benefits under circumstances which might be construed by reasonable person as influencing the performance of his governmental duty. Make no private promises.
You have 1 minute left.
All right, pause. I'm gonna call you right back then, okay?
All right. Go ahead.
All right. Also, never discriminate unfairly by the dispensing of special favors or privileges to anyone. Also, make no private promises of any kind binding upon the duties of office, since a government employee has no private word which can be binding on public duty. Neither can they engage in no business with the government, either directly or indirectly, which is inconsistent with the conscientious performance of his government duties. All right, now I also have the transcripts that were written by appearances on behalf of the state, Joanna Helsby, Assistant District Attorney, on behalf of the defendant pro se, and the court reporter was Latasha D. Bethel. Now, in the transcripts, the Honorable Judge David B. Irwin, courtroom 7, he threatened, first he undermined the Attorney General, and that's on page 44. He says, you are not listening to me. I'm about to gag you, is what I'm going to do. I have the authority to do that if you are disruptive to me, and your continuing to comment is disruptive to me. Also, secondly, court says, it says, I do not have any mental health issues. Obviously, I'm competent enough to present myself, and that's the defendant's talk. The question was, I'll be honest with you, judges will recuse themselves answer. She recused because she is aiding and abetting the Assistant District Attorney, Joanna Steiner Helsby, in an attempt to unlawfully convict me by using subordination of perjury with an illegally subpoenaed false witness named Melissa Denise Jordan on the stand under oath in front of the jury during trial. February 9th, 2022 is a severe violation of OCGA 45-11-4 and multitudes of other official codes of Georgia. I do not understand why the brutal violation of OCGA 45-11-4 by Joanna Helsby has not been reported to the State Attorney General Christopher Carr. First went to OCGA 45-15-11. And then the judge says, well, if you are putting your hope in the Attorney General, who did not practice law when he was appointed Attorney General and has to repay his bar dues, then your hope may be misplaced. This is all I will tell you, because it is not just knowing the numbers, it is actually knowing who lawyers are. Okay. Also, I'm trying to zoom through this, y'all. Bear with me. Second, the other offense is 51 Georgia Code annotated 51-6-2, which means deceit, misrepresentation of facts, concealment of fact, knowledge of falsehood, willful misrepresentation of a material fact made to induce another to act upon which such person acts to his injury will give him a right of action, more concealment of a material fact, unless done in such a manner as to deceive and mislead, will not support an action. In all cases of deceit, knowledge of the falsehood constitutes an essential element of the tort. A fraudulent or reckless representation of the fact as true when they are not, if intended to deceive, is equivalent to a knowledge of their falsehood, even if the party making the representation does not know that such facts are false. That's like saying, like, look, just because you're doing something you don't know you don't got no business doing does not mean that it's not illegal. Also, what's the next question? What happened? Oh, I read that. I just read that. What happened to Mr. Davis July 6th motion hearing? What happened to Mr. Davis' case is his judge recused himself once they found out that they were doing something wrong, because he mentioned another case, and she left the stand. How much time? You can find, for answer number 5, you can find these cases on www.dekalbstatecourt.net. Then click case search, then circle smart search. Then click smart search, then type in the indictment number 19 CR 2976, 21 CR 1475, or 21 CR 2124. Now, some of the letters that I've just read, when you go to those case numbers, they are removed. So, there you go. It says, how much time does the trial court have to retry a case after a mistrial? Now, listen to this. It says, in U.S. Code subsection 3161, time limits and exclusions, U.S. Code, U.S. law, is that if defendant is to be tried again following a declaration by the trial judge of a mistrial, following an order of such judge for a new trial, the trial shall commence within 70 days, right? Now this is what I'm saying. If DeMonte Anderson, they declared a mistrial, he's been in this jail for 877 days. That is 12 70-day cycles, or, because they also says that from the date the action occasioning the retrial becomes final, if the defendant is to be tried again following an appeal or a collateral attack, the trial shall commence within 70 days from the date the action occasioning the retrial becomes final, except that the court retrying the case may extend the period for retrial not to exceed 180 days from the date that action occasioning the retrial becomes final if unavailable, witnesses, or other factors resulting from passage of time shall make trial within 70 days impractical. The periods of delay enumerated in section 36, 3161 and section 3161H are excluded in computing the time limitation. Now, I computed the time. Now, again, he's been here 877 days, right? So it's 877 days. That's 12 70-day cycles. Or if you want to look at it, that we're 180 days, that is six and a half 180-day cycles. The man was supposed to be released once there was a mistrial. A mistrial means that the case is over. They get a do-over. Anything they had or anything that they were going to use, any witnesses to the fact, are null and void. Why is he still sitting there? How long has Mr. Anderson case been pending since the mistrial? Okay, it's 877 days or 12 retrial days. All right, that answers that question. Also, according to the what article is this? It says discipline removal and involuntary retirement of district attorney. Any district attorney may be discipline removed or involuntarily retired as provided by general law. And it also says in paragraph 7 of what article is it? Oh, here we go. This is Article 4. It says discipline, removal, and involuntary retirement of judges. Any judge may be removed, suspended, or otherwise disciplined for willful misconduct in office or for willful and persistent failure to perform the duties of office or for habitual intemperance or for conviction of a crime involving moral turpitude or for conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. Any judge may be retired for disability which constitutes a serious and likely permanent interference with the performance of the duties of office. The Supreme Court shall adopt rules of implementation. Okay, also, canon rules and commentary. It says judges shall uphold the independence, integrity, and impartiality of the judiciary. And it says Rule 1.1, preserving judicial independence, integrity, and impartiality. An independent and honorable judiciary is indispensable to justice in our society. Judges shall participate in establishing, maintaining, and enforcing high standards of conduct and shall personally observe such standards of conduct so that the independence, integrity, and impartiality of the judiciary may be preserved. The provisions of this code should be construed and applied to further that objective. Also, Canon 2, judges shall avoid impropriety and the appearance of impropriety in all their activities, complying with the law and promoting public confidence in the judiciary. Judges shall respect and comply with the law. Now, mind you, I've read all the law. And shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary. And it says, Commentary 1, public confidence in the judiciary is eroded by irresponsible or improper conduct of judges. Judges must avoid all impropriety and appearance of impropriety. Judges must to be the subject of constant public scrutiny. Judges must therefore accept restrictions on their conduct that might be viewed as burdensome by the ordinary citizen, and they should do so freely and willingly. Let's see. The prohibition against behaving with impropriety or the appearance of impropriety applies to both the professional and personal conduct of the judge because it is not practicable to list all prohibited acts. The proscription is necessarily cast in general terms that extend to conduct by judges that is also, although not specifically mentioned in the code, Actual improprieties under this standard include violations of law, court rules, and other specific provisions of this code. The test for appearance of impropriety is whether the conduct would create in reasonable mind a perception that the judge's ability to carry out judicial responsibilities with integrity, impartiality, and competence is impaired. Also, respecting the prestige of judicial office. Rule 2.2. That's canon 2. If judges shall not permit family, social, political, financial, or other interests or relationships to influence the judge's judicial conduct or judgment. Judges shall not lend the prestige of their office to advance the private interests of the judge or others. Judges shall not convey or enable others to convey the impression that any person or organization is in a position to influence the judge. Judges shall not testify voluntarily as a character witness. Canon 3. It says judges shall perform duties of judicial office impartially, competently, and diligently. Rule 3.1. Giving priority to judicial duties in general. The judicial duties of judges take precedence over all their activities. Their judicial duties include all the duties of their offices prescribed by law, but primarily judges serve as the arbiters of facts and law of the resolution of disputes. Judges shall be faithful to the law and maintain professional competence in it. Judges shall not be swayed by partisan interest, public clamor, or intimidation or fear of criticism. Commentary. To ensure that judges are available to fulfill their judicial duties, judges must conduct their personal and extrajudicial activities to minimize the risk of conflict that will result in frequent disqualification. Avoiding bias and prejudice. 3.3. Judges shall perform judicial duties without bias or prejudice. A judge shall not, in the performance of judicial duties, by words or conduct, manifest bias or prejudice or engage in harassment, including but not limited to bias, prejudice, or harassment based upon age, disability, ethnicity, gender or sex, marital status, national origin, political affiliation, race, religion, sexual orientation, or socioeconomic status. Judges shall not permit court staff, court officials, or others subject to the judge's direction and control to do so. Commentary. Judges must refrain from speech, gestures, or other conduct that could reasonably be perceived as prejudice or bias or as harassment, and must require the same standard of conduct of others subject to their direction and control. Judges must perform judicial duties impartially and fairly. Judges who manifest bias on any basis in a proceeding impairs the fairness of the proceeding and bring the judiciary into disrepute. Facial expression and body language, in addition to oral communication, can give to parties, lawyers, juries, the media, and others an appearance of judicial bias. Judges must be alert to avoid behavior that may be perceived as prejudicial. And we read the transcript, so y'all heard all the craziness. Let's see. It says judges shall require lawyers in proceedings before the court to refrain from manifesting bias or prejudice or engaging in harassment based upon attributes including but not limited to age, disability, ethnicity, gender or sex, marital status, national origin, political affiliation, race, religion, sexual orientation, or socioeconomic status against parties, witnesses, lawyers, or others. This rule, 3.3b, does not preclude legitimate advocacy with age, disability, ethnicity,
Hey, Banana.
gender, or sex. Yeah.
Hold on, pause.
All right. Rule 3.4, assuring fair hearing and averting ex parte communications. Judges shall accord to every person who has a legal interest in proceeding or that person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communication or consider other communication made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter subject to the following listed expectations. Judges shall immediately stop any attempted improper or communication. The right to be heard is an essential component of a fair and impartial system of justice. Addressing limits on the scope of evidence that may be legitimately considered by. All right. Next, general provisions. Rule 5. It says Rule 6 ground for discipline sanction, felony indictment, or conviction.
You have 1 minute left.
Oh my God. All right. If you can't stop the video, pause the video.
Recording. I'm recording.
All right, here we go. All right. I know it's a lot of information, y'all, but just bear with me. This is my last little bit of information. Georgia Code annotated 15-11-1 says, any public officer or other person shall steal, embezzle, alter, corrupt, withdraw, falsely falsify, or avoid any record, process, charter, gift, grant, conveyance, or contract, or shall knowingly and willingly take off, discharge, or conceal any issue, forfeited, recognizant, or other forfeiture, or shall forge, deface, or falsify any document or instrument recorded or just pause it again. I'll be right back.
Go ahead.
I got y'all. Let me finish this video. I got y'all. All right, hello?
Yeah.
All right, yeah. This is Dr. Here. All right, I'm ready. You let me know you're ready.
We're ready, baby.
Go ahead.
Go ahead.
All right, anyway, all right, the next one, there's a lot of information, y'all. Georgia Criminal Trial Practices, subsection 1541, 2023 to 2024 edition, dismissal by trial court. It said the trial court generally may not deprive the state of its opportunity to prosecute the defendant, except where such prosecution was violating the defendant's constitutional right, or there is a defect on the face of the indictment or accusation. Thus, in State versus Blackwell, the Court of Appeals approved the trial court's dismissal of felony drug and related charges where the state crime lab had destroyed key exculpatory evidence in violation of the trial court's order to preserve evidence, thus violating the defendant's right to due process. All right, next one is common law as a form of law, and that's 15A CJS common law subsection 2. And it says common law is only one of the forms of law and is no more sacred than any other. The great fundamental object and principle of the common law is the protection of the individual and the enjoyment of all inherent and essential rights, and to afford the individual a legal remedy for their invasion. The function of the common law is not to achieve a result in a particular case, but to establish generally applicable rules to govern social societal behavior. No right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of their own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law. The genius of the Anglo-American common law is its readiness to proliferate needed remedies for newly evident wrongs and to apply existing remedies with liberty to new aspects of recognized wrong. All right. There are many other laws I got here, but I'm going to save that for another video. Again, this is a Shelton Jet. I read for y'all the Bill of Rights, Article 1, Section 1, rights of a person. No person shall be deprived of life, liberty, or property except by due process of law. And that's paragraph 1, life and liberty. Paragraph 2, no person shall be denied the equal protection of the law. Paragraph 7, citizen protection of all citizens of the United States residents in this state are hereby declared citizens of this state, and it shall be the duty of the General Assembly to enact such laws that will protect them and the full and just enjoyment of the rights, privileges, and immunity due to such citizens. Again, this is a show that I've been seeing a couple others. It's 95%.
You have 1 minute left.
Yeah, 95% of the indictments here are false and fake. I just want to thank y'all. I love y'all. God bless y'all. I love you. God bless you. I love you too. Just help. Any help y'all can get, please watch the video. Any help y'all can get, watch the video. Everybody else knows. God bless you. See the grace of me and my wife and my children. But all this craziness will stop and the truth will come to out. All right? I'll call you tomorrow. I'll pick it up.
All right, honey.
Make sure you upload it, okay?
I am.